From the time a lawsuit is filed to the time you get to trial, the general rule of thumb is it takes about 2 years. However, every once in a while we'll have situations where our client, maybe their business or their individual needs, can't wait for that 2-year period to have some of the harm stop. They need immediate action taken by the court to stop some of that ongoing harm. There is a mechanism in place in the law that's called getting a temporary restraining order or a preliminary injunction against the person that they're suing to stop that person from continuing to do the harm that they're doing. Attorneys need to be familiar with the rules that govern obtaining and procuring a proper temporary restraining order and preliminary injunction. We here at Denton Peterson are familiar with those rules that govern that, and we deal with them on a fairly regular basis. The court will look at basically 3 things. Number 1, the court needs to determine whether there's any other adequate remedy at law. Number 2, whether you are substantially likely to win your case. And then number 3, the court wants to make sure that the benefit that you're going to receive is going to be far greater than any harm against the defendant that you're getting the temporary restraining order against. For example, going to number 1, is there no other adequate remedy at law? If your argument to the court is, look, what this person is doing is costing our business, for example, $100 a day, and that's it. It's costing us $100 per day. And we can't wait for 2 years, a year and a half to get to trial. The court is going to look at that and say, well, that's a money damage, and at the end of the day, you can be compensated with money. So you're likely not to get a temporary restraining order or preliminary injunction in those circumstances. Conversely, if you say, hey, what this person is doing, they're stealing our secrets, and they're stealing our business secrets and our customers away, and in 2 years from now, our business is going to be gone, the court will look at that and say, you can't be adequately compensated with money. There is no other adequate remedy at law. So, okay, yeah, we will go ahead and put a preliminary injunction in place so long as, again, the harm to you is greater, or the harm to them is less than the benefit to you, and finally, that you're substantially likely to win the case. The court wants to make sure that you have a very strong likelihood of winning your case, not just maybe there's a little chance, because it's a pretty firm result that they're going to be giving to the other side, and it's going to stop the other side from doing certain things. And if you meet those 3 criteria, then there's a good chance you can get a preliminary injunction. And we here at Denton Peterson have experience doing this, and we can help you jump through that process and the hoops that are necessary to procure that preliminary injunction, which is a great mechanism in the law to help clients with their immediate needs.